Roe, if you look at our country, it was 1973 when this was decided. So we'd been around almost 200 years. In 200 years, nothing in the Constitution had ever said a word about abortion. For 200 years, it had been up to the states, and the states had laws regulating abortions. And if you disagreed with those laws, you went to the state legislature and you argued we should change the law. And actually, in 1973, there were some states that were changing the laws. There were real and democratic debates, and people were having disagreements. And what the court did, 7 justices in Roe did, is said, you know, you pesky voters, you don't get to decide this. We know better than you. And the reasoning, so you think about, all right, well, what in the Constitution would make abortion a constitutional right? It doesn't provide for a constitutional right. The word abortion is nowhere in the Constitution. The majority opinion by Justice Blackmun is actually, it's agreed by left and right. It's one of the worst Supreme Court opinions ever written. Blackmun, I'm trying not to speak ill, but was a thoroughly mediocre justice. And this was, it reads like legislation. So where did the court find the right to abortion? It found it in what was called the right to privacy. You say, oh, okay, well, what does the Constitution say about the right to privacy? Nothing. You look for the word privacy in the Constitution, it's not there. What the justices had said in preceding years, in earlier cases, the justices had created a right to privacy, and there are all sorts of rights. There's a Fourth Amendment right against unreasonable search and seizure, so your home or your property can't be searched or seized. There are rights not to have soldiers forcibly quartered in your homes. That's the Third Amendment. There are a series of rights that protect aspects of privacy that are unquestionably part of the Constitution. What the Supreme Court had said before Roe, and it used really metaphysical language, it said these rights that are protected in the Bill of Rights, they have emanations. Basically, they glow. And those emanations cast penumbras. Now, penumbras, if you're not a law nerd, you may not know what a penumbra is.
I love how nerdy this is.
This is perfectly nerdy.
So penumbra is just a 10-penny word for shadow.
Right?
And, you know, we've got lights in the studio. They're shining lights, and they are casting penumbras of our brown leather chairs behind us. And what they said is, in the penumbras cast from the emanations, we find the right to privacy. Now, if that doesn't make any sense to you, that is because you actually are engaged in logic and reason, because they just made that up. And then, so you've got this right to privacy that's not in the Constitution. There are other rights that certainly are in the Constitution, but this broad, full-form right to privacy is mentioned nowhere in the Bill of Rights. Fast forward to Roe, they said within the right to privacy, we find the right to abortion. And with that, they declared the laws of states all over the country. They just threw them out and said you silly voters don't get to decide.